case briefs, and so much more. LSData's got what you're looking for.
In a groundbreaking 1995 case, Elizabeth Maxwell opposed Fidelity Financial Services, Inc., challenging the terms of her contract for a solar home water heater. Maxwell bought the heater from the National Solar Corporation and financed the purchase through a loan from Fidelity. After allegedly being subjected to high interest rates and inadequate installation, Maxwell protested the contract. 4 years later, in 1988, Fidelity produced a new contract encompassing the remaining balance, a term life insurance charge, plus a fresh loan. Maxwell objected, asserting the unfairness of the contract. The key question faced by the court was whether the loan contracts could be deemed unconscionable. If they were, they would be rendered unenforceable. The court, taking into account both procedural and substantive unconscionability, found that the loan agreement, initially touted at $6,500 ballooning to a total repayment of $14,860.43, including its security terms, was potentially exploitative and could constitute unconscionability. Further analysis, however, was necessary. The court directed the trial court to reassess the evidence in their evaluation of whether the contract was unconscionable, keeping in mind their commercial setting, purpose, and impact. Was Fidelity trying to make excessive profit by leveraging a vulnerable person? Answering this inquiry was left to the expertise of the trial court. After these requisite considerations, the case was sent back to trial level for additional proceedings. The ruling made by the Supreme Court clarified that rebirth of a potentially exploitable contract in a new form with significantly similar terms was not permissible. The Vice Chief Justice and Justices Corcoran and Zlackett concurred with this decision.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.